Morning, everyone. I know as a lawyer, the tools of my trade are supposed to be words, but I am no match for the politicians that went before me. So I ask all of you to be patient with me. My topic may not sound as exciting as leadership, that's for sure. So with that, what I'm going to talk about today is establishing and promoting health rights in Bangladesh. To be more specific, the work that I have done to do my bit to bring about some change in this sector. So when we speak of health rights, there is no room for debate that the healthcare system in Bangladesh needs to be reprioritized in the national agenda. The pandemic has taught all of us how fragile, how weak our healthcare system is. And even before that, the newspapers are littered with incidents of medical negligence. The newspapers are littered with incidents of denial of emergency medical care to critical patients, which actually reached a new height during the pandemic. And of course, we have heard from experts time and again that there's a critical shortage of doctors and nurses and midwives. There is persistently low budgetary allocation to the healthcare sector, despite the sector being of critical importance to public health. And of course, the weak legal and regulatory framework governing the healthcare sector in Bangladesh. So this is not something that doesn't affect most of you. And I can bet that most of you, if not all of you in the audience, or your loved ones have, at some point or another, had bad experiences when availing healthcare services in Bangladesh. I can bet on that. So it's something that we can all relate to. Rich, poor, young or old, man or woman, it really doesn't matter. It affects us all. For example, if I am a pregnant lady and in the middle of the night my water breaks and the child that I'm carrying is in distress, if I'm having a heart attack, or if I've just sustained life-threatening injuries in a road crash, which by the way is extremely common and the statistics are absolutely harrowing, I won't have the time to fly to Singapore, even if I can afford to at that point. So that is how important healthcare is. And that is what really motivated me to do my bit using the skills at my disposal to initiate and establish and promote health rights in Bangladesh through public interest litigation, which is what I'll be talking about today. So we have been speaking about health rights for the last few minutes. What do I mean by health rights? Well, international instruments have recognized health rights globally. For example, the Constitution of the World Health Organization has recognized health right, and it entails the enjoyment of the highest sustainable standard of health is one of the fundamental rights of every human being without distinction of race, religion, political belief, economic or social condition. Even other than that, the Universal Declaration of Human Rights, another international treaty to which Bangladesh is a signatory, the International Covenant of Economic, Social and Cultural Rights, again we're a signatory to that. All of these international instruments have recognized the health rights. What does that mean for Bangladesh? That means that as a country, it is our international obligation to continuously improve public health, to ensure provision of medical care. And it's not just in the international sector either, international space either. At the national level, the Constitution of Bangladesh recognizes health rights. I don't know if there are lawyers in the audience. They may be able to understand this better. But the Constitution of Bangladesh does not expressly make the right to health a constitutional right, a fundamental right. So what does fundamental right mean? It basically means that these rights are enforceable by the High Court Division of the Supreme Court of Bangladesh if violated. So while the right to health has not been made a fundamental right, it has been read into a fundamental right, which is the right to life, which is one of the most important fundamental rights guaranteed by our Constitution. So judges over the years, through judgments, have read into the right to life, the right to health. So it is very much judicially enforceable right now. Even other than that, there's a part in our constitution called the fundamental principles of state policy. So simply put, this basically means what are the primary duties of the state, what is it that the state needs to keep in mind when discharging their duties, their constitutional duties. And even in that part, in Article 15 and Article 18, we see the right to health, steady improvement of public health, provision of medical care. So all is well and good. So far as the paperwork is concerned, it's all there. But the problem is when we look at the legal and regulatory framework that governs the healthcare sector in Bangladesh, it leaves a lot to be desired, to say the least. Why do I say that? Well, we realized through a lot of research that there were some alarming trends in the healthcare sector in Bangladesh. What were those trends? Well, some of them were an alarming rise in medically unnecessary cesarean sections. A lot of you may have friends and family who've gone through C-sections when they did not actually feel that there was any need for it, either at the hands of private hospitals or doctors, or some sort of pressure exerted by the doctors. The second trend we noticed was a denial of or failure to provide emergency medical services to critical patients. They were being refused, they were being turned away, especially during the pandemic. The newspapers were littered every day with harrowing stories of how people were denied treatment. They went to 3 different hospitals only to be turned away, and by the time they reached the 4th hospital, the person was declared dead. This happened many times during the pandemic and even before, so it's not a new trend. And the third one was the dire shortage of kidneys for transplantation in Bangladesh, which directly fueled the black market for kidneys that exists in Bangladesh, which exploits the poor. So when we dug a little deeper and looked at the laws that govern the healthcare sector, we realized 3 things. First, either the laws are silent about these issues. 2, if the laws are not silent, they don't deal with the issue adequately, they're probably obsolete. And 3, which is the worst, at times the law itself contributes to the problem. So this was a very disturbing revelation when we carried out legal research of the laws in place. And that's when we decided to join hands with NGOs and file public interest litigations to bring these very important issues of national interest that affects us all before the High Court Division for relief. So one of the first cases that we filed was to check medically unnecessary C-section rising. Well, what was the exact nature or the severity of the problem? As you can see, the World Health Organization said that no country in the world should have a C-section rate that goes above 10 to 15%. Shockingly, in Bangladesh, the rate was 31% and rising. So what does that mean? That means that C-section, which is supposed to be a life-saving intervention for the mother, was being conducted unnecessarily. It was not medically required, it was still being done. What are the adverse effects of C-section? Some of us may be aware that there are health implications for the mother, for the child, and it's very expensive for families. This leads me to the causes behind this rise. Well, one of the causes was that we found no law that specifically governs maternal health rights or maternal health care. And another reason, of course, most of you may have heard of this because the media loves to pick this up, which is revenue generation interest of private hospitals, which is a big reason. I'm not saying that it's not a big reason. However, this is not the only reason. If the regulators were doing their job, if they were monitoring private hospitals, this would not have happened. So it's not just a practice of the private hospitals, it's also a failure of the regulator. Another reason was the dire shortage of doctors and midwives in Bangladesh. The doctor-to-patient ratio is absolutely shocking. Lack of skills and competencies to do a normal vaginal delivery. Apparently, this is more complicated than a cesarean section. So we have to train our doctors, train our midwives, deploy midwives to hospitals to carry this out. So we filed a case on behalf of BLAST, a leading NGO in Bangladesh, And we sought formation of a multi-stakeholder committee. The function of the committee would be to frame comprehensive guidelines which would cover maternal health and which would cover C-sections. The idea was that this guideline would be given the force of law through the judgment, and this guideline would contain comprehensive provisions on how to regulate C-sections in Bangladesh. Some of those include, first and foremost, what are the clinical indications of C-sections? When is a C-section necessary? Another one would be national level campaigns to raise awareness about the harmful effects of C-section, and of course to promote normal vaginal delivery, because there is a lot of myth attached to it as well. And then reporting obligations. If we are to strengthen the monitoring of the regulators of private hospitals, then private hospitals have to be asked to regularly report to the regulators. They have to be asked to regularly keep records. If I want to file a case, if I've been a victim of medical negligence, and if there are no records, then what is the judge going to decide my case on? And this is why medical negligence doesn't even work, because of the atrocious state of record keeping in our hospitals. So all of this came out in the guidelines, and the guidelines have been framed, submitted in court, and the case is now pending final disposal. So this was a big victory for maternal health rights at that point. I'll quickly move on to the second case that we filed, again on behalf of BLAST, which is a leading NGO, which is failure to provide emergency medical services, specifically to road crash victims. Why I say specific is that there is a factual background to this case. A young boy of 18, he was helper in a bus. He slipped, fell off his bus, and his bus ran him over. So he was lying there, bleeding to death, the lower part of his body completely crashed, when a good Samaritan who was passing by picked him up, went to 3 different private hospitals, really big ones, only to be refused critical care to this dying patient. And what was the reason given? The reason was, it's a medico-legal case, so you have to go file a police report, then come to the hospital. So by the time he managed to do it, and they reached the 4th hospital, the poor boy was declared dead. Now we don't know enough to know if his life could have been saved, but there are many such incidents where if you're given critical care within what is known as the golden hour, which is a 60-minute period from the time you sustain the injury to the time you receive treatment, it's possible to avoid death, it's possible to avoid permanent injuries. So that is what prompted us to join hands with the Good Samaritan, Saif Kamal, and Bangladesh Legal Aid and Services Trust to file a case before the courts, and again we sought the exact same relief. Form a multi-stakeholder committee, let there be expert consultations, form a set of guidelines, and then these guidelines will fill up the vacuum that exists in the law. Interestingly, when I was being interviewed by one of the TV channels for this case, they asked me a question, which was actually a very basic question. They're like, something as simple as emergency medical care, isn't it obvious that they have to give it? Why do you need a law that specifically says so? Unfortunately, we do. Otherwise, the state of affairs wouldn't be such. So what we sought in these guidelines is that these guidelines have to specifically say that private hospitals have to provide emergency medical care. It doesn't matter if the patient is financially unable to pay on the spot. It doesn't matter if it is a medico-legal reason, and people have been refused for political reasons as well. So none of those matter. The first and foremost responsibility of these hospitals is to save the life, to stabilize the person. Another excuse used time and again by these hospitals who want to avoid the hassle of getting into a medico-legal case is that we don't have the facilities. So the guidelines went on to say, if you don't have the facilities, you still have to screen and stabilize the patient, and then you have to ensure that the patient is transferred to the nearest hospital that has the facilities. So a fairly comprehensive set of guidelines. I sat in a number of these expert consultations that had heads of emergencies, bureaucrats, police, so on and so forth. Another very important thing that came out in these guidelines is protection for Good Samaritan. So what is a Good Samaritan in this context? A Good Samaritan is a person who does the critical job of transferring this patient from the accident spot to the hospital. Why is this a critical task? in our context, because in Bangladesh there is an atrocious paucity of ambulance services. We have a handful of ambulance services, and the ones that are there, the state of infrastructural and equipment-wise, absolutely hopeless. Because ambulance is supposed to provide the critical pre-hospital care to these patients. As we see in movies, paramedics trying to stabilize the patient while they're carrying the patient to the hospital. So we have a lack of ambulance services. That is why it is important that we encourage citizens to come forward and do this critical part of transferring the patient. However, because these good Samaritans, whenever they've done so, face a lot of harassment at the hands of the police, at the hands of the hospital authorities, and at the hands of the courts, they are asked to appear time and again. If it's a crime, they avoid or they shirk from this basic civil duty. So what is to be done? We thought that if the guidelines have enough protections for these, that you will not be harassed, you will not be asked to pay, you will not be forced to appear in court if you don't want to, then more and more people would actually come forward and do this, as has happened in India through a case before the Supreme Court of Bangladesh. So we found a very comprehensive set of guidelines, and the judgment endorsed these guidelines and gave them a force of law, plugging the legal vacuum that existed so far as emergency medical services are concerned. Moving on, our next case, dire shortage of kidneys for transplantation. Let me share with you some of the statistics. Around 20 million people in Bangladesh suffer from kidney disease. And out of this 20 million, every year, roughly 5,000 to 9,000 patients need kidneys for transplant. And out of that, only 120 manage to get it. The rest comes either from the black market of kidneys, which exploits the poor, or the patients continue with dialysis. And it has been seen that on an average, within 2 years, patients stop doing dialysis because it takes a financial toll on the family. It takes a toll on your life. It reduces your quality of life. So inevitable adverse effect is death. So the right to life, which is fundamentally guaranteed, is violated by this. And of course, a booming illegal black market for kidneys in Bangladesh. Because if I am in my deathbed and I desperately need a kidney, I will resort to all sorts of means to try and save me or my family member. So you're sort of forcing people to do something that's breaking the law, because the law itself is that archaic. So what was the problem with this? One of the problems we identified that we could make a difference to was there is an act called the Human Organ Transplantation Act 1999. And this act contains a definition of donor, a very narrow definition. It basically gives a list of near relatives who can donate a kidney to you. So if that list could be expanded in line with the global trend, and the global trend is allowing donation for emotional and altruistic reasons, then this would go a long way in making more kidneys available. Another thing we wanted to target was to facilitate cadaveric donation. So donation of your organs after you die to someone who needs it. This also needs to be facilitated and promoted. Again, we filed a case on behalf of the mother of a kidney patient, a young girl of 20 studying zoology in Dhaka University. And we asked for this particular section of the law to be struck down because it directly affects the right to life guaranteed under the Constitution. And what was remarkable in this case was the moment it was filed, this made headlines. That sort of made us realize the enormity of the problem and how many people were suffering because of this. And during the pendency of the case, before we even got to judgment, the first set of law reforms actually took place. So the power of a public interest litigation done for the right reasons, for the right causes, was tremendous. So for the first time, we saw that the definition of donor was expanded to include a host of other relatives in the list of donor. And a cadaveric national committee was formed to oversee cadaveric donation. And many other recommendations that we had specifically made in the writ petition were actually incorporated in the new law. But we still went on to push for something more, and that was to allow donation for emotional reasons. Bear with me here. When I mean emotional, what I mean by emotional reasons is that I may not be that close to my first cousins. They may not want to donate their kidneys to me, but my best friend for 30 years may want to do that. So if a person wants to donate for emotional reason, after establishing that this is the real reason for the donation and there's no illegal trading going on, that person should be allowed to do so. And this is very much in line with the global trend that we see. Globally, many countries allow charitable reasons donation as well, even if you're not related to the person or even know the person. And of course, emotional donation is also allowed. So eventually we got a judgment that directed the health ministry to take steps to amend this law in line with the observations made in the judgment about emotional donation and several other factors to facilitate and make more kidneys available. So to sum up, the impact these three PILs had was tremendous. It started a national conversation. I saw young people getting engaged in this conversation. I saw young people learning about these issues that they're bound to face sooner or later in their lives. It initiated law and policy reform, as I said, even during the pendency of the case, before judgment. And last but definitely not the least, it filled up a legal vacuum that existed. So up until a law is enacted to address this specific problem, the guidelines would serve as the law. We all know lawmaking is a very long process with multiple lobbyings working to change each and every word in that law. So while we wait for that, we don't have to live in a vacuum and let these issues go unaddressed. So this is the purpose that it served. However, it is at that point that I realized, unfortunately, that the battle had just begun. Initially, I was too busy celebrating about the impact that the work that I was involved in was creating. But I had to wake up sooner or later to realize that it had just begun. And why do I say that? Because implementing these judgments was very, very, very difficult. Implementation was the next big challenge that I had to overcome. And it is at that point that I started feeling very humble. And I realized that one person can never really make a difference, as you have to join forces. So we started joining forces with NGOs, we started joining forces with citizens platforms to do continuous advocacy for enforcement of these judgments and orders, because the order is just a paper order if it's not implemented. And I realized that this is a journey that will continue throughout my life. And if together we can make enough noise, then the regulators, the policymakers, the lawmakers are bound to sit up and take notice sooner or later. So I urge all of you to lend your voices, to lend your support to these campaigns, to these causes, as you stand to get affected sooner or later. It's just a matter of time. It's healthcare after all. Thank you.